Car accident negligence claims. The basics. If you have been involved in a car accident and you want to prove that another driver was at fault, you will have to establish that they were negligent. The basic parts of a claim such as this involve duty, breach, causation, and lastly, damages. However, these terms may have no meaning to you if you are not familiar with the insurance industry or law. Let's take a look at each of these elements. The duty of care. Every single driver in every single state across America has a legal duty to ensure they operate a car in a manner that is deemed non-negligent. This means they should not drive in such a way that is potentially harmful to any other drivers and any property. Every single driver is taught this the very first time they have a driving lesson, and it's quite a straightforward lesson. In addition to driving with a duty of care, they should also obey their state's traffic laws in addition to the speed limits and any traffic signs. However, many drivers seem to take these rules for granted and therefore behave negligently. The breach of duty of care. When it comes to breaching the duty of care, it's not always clear what this may be. However, a breach of the duty of care can be defined as someone who chooses to operate a vehicle in a negligent way, and in such a way that another person or property could potentially be harmed. Some breaches, such as speeding, failure to use a turn signal, or going through a stop sign, can be considered to be quite minor, and these breaches tend to occur every day without anyone being injured. If a minor breach results in a car accident, this is when the term negligence is used, and when liability needs to be determined. Some negligence claims can involve what is known as egregious or shocking breaches of duty. These claims often involve reckless speeding, driving under the influence, or running a red light, and these behaviors can result in injury or death. In some cases, breaches may be intentional, which means a negligence claim can be moved from a civil to a criminal court depending on the circumstances. Causation and damages. The last two elements of a car accident case that involves negligence tend to be best understood if they are discussed together because they are quite closely related. If it is found that another driver breached the duty of care and it was this that caused your injuries, you may well win your case. There are two variations of causation: cause in fact, and proximate cause. Cause in fact relates to a driver's breach of the duty of care being the cause of the injury. For example, if a car hit another car and the crash resulted in the other driver sustaining a broken arm, this act will be deemed as the cause in fact. In the case of proximate cause, which is also known as but for causation, a breach such as the act of speeding may not have been the direct cause of the damage. The damage, the broken arm, would not have been caused but for the breach. In other words, if the driver had not been speeding, the other driver's arm would not have been broken. Different types of damages. There are many different types of damages that can be as a result of a car accident. Damages can involve injuries to an individual, monetary damages, physical damage, or pain and suffering. Please read our article "What is Pain and Suffering?" for more information. Damages can again be broken down into two more categories: economic damages, which can be accounted for in terms of monetary value, and non-economic damages, which could be referred to as pain and suffering. State variations on car accident laws. You should be aware that the elements of a negligence claim that involve a car accident do not vary between states. However, some states to vary in terms of their jurisdiction. Some parts of the United States are known as no-fault states, and these require every driver to have car insurance and to use and make a claim on it irrespective of who was at fault for the accident. Some state laws can vary with regards to how an injured person's negligence may affect the case that has been brought against the other driver. If you have sustained an injury due to being involved in a car accident that was another driver's fault, please speak to a personal injury lawyer because you may have a personal injury claim.